The third area we want to look at is substance abuse patient records and that redisclosure issue. Unlike FERPA and HIPAA, substance abuse patient records are much more tightly controlled by the federal statutes. 42 CFR Part 2, or Part 2 as it's often stated, deals with the confidentiality of alcohol and drug abuse patient record regulations that apply to the records of identity, diagnosis, prognosis, and treatment of patients maintained in connection with the performance of drug abuse prevention functions, conducted, regulated, or directly or indirectly assisted by any department or agency of the U.S. government. So basically, anybody involved in funded alcohol, drug abuse, patient care, patient assessment, prognosis, counseling, diagnosis, etc., is covered by Part 2. This regulation generally prohibits any redisclosure of the substance abuse information. And it also requires that a notice accompany each disclosure made with a patient's written consent. And that notice must state that this information has been disclosed to you from records protected by federal confidentiality rules, 42 CFR Part 2, that the federal rules prohibit you from making any further disclosure or redisclosure unless that further disclosure is expressly permitted by written consent of the person to whom it pertains, or as otherwise permitted. A general authorization for release of medical or other information is not sufficient for this purpose, and the federal rules do restrict that any use of this information to criminally investigate or prosecute an alcohol or drug abuse patient is prohibited. So what we have here is a very, very specific limitation on any disclosure, redisclosure, that says you have to have the consent. You have to have the written consent of the individual. And substance abuse and alcohol abuse patient records are not only consented to by parents. In most cases, they are consented to specifically by the individual who is receiving the treatment, in other words, the juvenile. While a program may devise its own notice or use the sample provided by the federal government, the program must include on the consent form a written summary of all state and program law and policy that is on this particular area that addresses this particular activity, and if it's policy at the state level that deals with specific agencies or specific activities such as counseling versus assessment versus a treatment group, this data must be defined because of the confidentiality of the records. Of course, there are some exceptions, limited exceptions, that allow some redisclosure to medical personnel to address a genuine medical emergency or if there is a court order. But the court is expected in the case of a court order to ensure that safeguards are placed on that court order and that that data that is released by court order is only specifically disclosed or redisclosed for a specific purpose to a specific individual and not made part of a general record. So let's look at a couple situations that identify this very difficult redisclosure limitation for substance abuse data. We said we can redisclose some health records, but can we redisclose behavioral health records received from one healthcare provider to another if that new healthcare provider is treating the patient? The answer is yes, with certain exceptions. The exceptions, of course, being state preemption issues for behavioral health, as well as Part 2, alcohol and drug abuse and other restricted health information that must be taken into consideration. So if a general record comes over from or is requested by a new provider of substance abuse patient care, if that record comes over and that record includes substance abuse data, psychological data, or mental health data, in addition to just specific assessment data, there may be a further redisclosure limitation placed on that, and the specific patient will need to consent to that redisclosure and that sharing. One that is more relevant to juvenile justice is the question of use of substance abuse patient records redisclosure in an assessment center. Juvenile justice assessment centers in various states complete triage actions on children and youth that are brought in by local law enforcement, schools, other justice and social service agencies, and parents. And these triage and assessments and reviews, and sometimes formal testing for drug abuse, alcohol abuse, substance abuse, behavioral, mental health, medical, etc., are conducted on both a mandated basis by programs within the state on a collaborative or for a particular justice area, as well as voluntary assessments. In these cases where an assessment center is completing these triage actions, do they have the ability to redisclose information, or do they need a specific consent from the parent, such as in the case of a substance abuse assessment, before the data available on the individual can be redisclosed to the assessment center, and at the end of the assessment, for the assessment center to disclose that data forward? The first place to look in this situation is, what is the reason for the appearance at the assessment center? Is the intake an emergency or to prevent a health and safety threat? If so, there may be an exemption that allows the entire data record and access to multiple sources of data about that child. Is it a school official looking at an assessment based upon a FERPA disclosure or redisclosure? Is it a law enforcement agency that's looking at what data is there? The child is picked up and brought into the assessment center by law enforcement because the child was wandering on the side of the road. At this point, do we have a substance abuse issue? Do we have a truancy issue? Do we have something related to schools, to medical, to substance abuse, neglect, etc.? So in these situations for a juvenile justice assessment center, we not only look at FERPA, HIPAA, and substance abuse, but we also have to look at the state rules. And that would include the processes and policies that have been established by memorandums of understanding and by local collaborative organizations regarding sharing the data. In the instances where the child is detained at the assessment center or is actually housed at the assessment center for a period of time, the Juvenile Justice Assessment Center may invoke other state provisions, such as specific laws, regarding access to data about that child that will ensure the safety, health, care, and provision of that child while they are in the facility. Many juvenile justice assessment centers also have time limits, periods in which they say, we will hold this child here for this period of time. We will attempt to get consent. If we cannot get consent, we then have to go to, is it an emergency situation, or do we need to release the child pending receipt of consent? So in substance abuse records with juvenile justice and juvenile justice assessment centers, it really is very situationally specific. Some frequently asked questions on substance abuse, though, need to be looked at. For example, if Adam gives covered information about participant Jack being participating in a substance abuse counseling program, let's say, to Ann, are further disclosures regulated by substance abuse regulations, such as through a drug court requesting the information, or a further assessment or juvenile team that is doing an assessment review of the child? The answer is yes. In substance abuse, Part 2, there is really no provision to say you can redisclose without consent. Each disclosure is, in effect, a new disclosure. So every disclosure of this data needs to be regulated, with the exception. The fact that the covered information about substance abuse with Jack, the fact that Jack has been participating in a substance abuse program, does not lawfully or otherwise allow anyone to move that data further without receiving some consent procedures and without providing Jack the opportunity to deny that disclosure. Another area where we're seeing a lot of frequently asked questions about substance abuse is with drug courts. Because drug courts are not really protected entities under HIPAA, and because drug courts are not really dealing with the actual treatment, but they want data about the treatment, the diagnosis, the status, the counseling, the opinions of an individual provider on a substance abuse patient, we need to look specifically at whether that data that is being requested is covered by Part 2 and/or state enabling legislation.